Hi, my name is Raj Sharma. I'm the managing partner of Stewart Sharma Harshani, one of Western Canada's largest dedicated immigration law firms. Today I'd like to talk to you about the massive changes in Canada's immigration law and policy that have taken place in the last 10 years. For most of the decade, changes to Canada's immigration laws have been led by Jason Kenney, without a doubt one of the most transformative ministers in this portfolio, at least within living memory. He has been succeeded by Minister Chris Alexander, but it's clear that the architect of most of the changes, if not all of the changes that we've seen in the last decade, has been Jason Kenney. There is no aspect of immigration law and policy that has gone untouched by this government. And we'll start off by looking at the changes brought in by the so-called Balanced Refugee Protection Act. There's no doubt that the refugee system was in need of reform. Claims were taking years to be heard, and there were multiple processes by which failed individuals would be in Canada for years before finally being removed. The Balanced Refugee Reform Act put an end to all of that. Now, claims are heard within weeks, if not a couple of months. There are changes and a lack of appeal for certain individuals, depending on which country you come from. Failed refugee claimants have limited ways of remaining in Canada, as there are restrictions on whether they can apply for humanitarian and compassionate grounds or for a pre-removal risk assessment. So there's a 12-month bar for H&C or PRA applications for many failed refugee claimants. There are some exceptions, and if you think that you fall within an exception, make sure you contact Experienced Immigration Counsel. In conjunction with the Balanced Refugee Reform Act, the minister sought other disincentives to dissuade individuals to come to Canada. A large part of the increased processing times and removal scheme under the Balanced Refugee Reform Act was to prevent or try to prevent individuals from coming to Canada to make fraudulent refugee claims. But there was no evidence to suggest that this was happening on any sort of large scale. In any event, the disincentives range from the farcical, like putting up billboards on the way to airports in Hungary and Romania, to the tragic, such as cutting refugee health. And so we were in a situation where we had cuts to maternal health, neonatal care, cancer patients. And of course, those cuts were reversed by Justice Anne McTavish of the federal court. The Harper Government is, of course, appealing that as well. Moving on to permanent residents. Permanent residents have significant rights in Canada, and a lot of permanent residents have been here for years, if not decades. The new act, the Faster Removal of Foreign Criminals Act, allows the removal of even long-term permanent residents for even penny ante crimes. So if you get sentenced and convicted to more than 6 years in jail, you will have loss of an appeal right, and you will face removal from Canada. This is unfortunate because the act doesn't distinguish between the type of crime, whether it's white collar or violent, and it doesn't distinguish between the length of the stay of the permanent resident. And so you're going to see Jason Kenney's hard law makes for bad cases. And we're going to see unfortunate situations of this heavy-handed policy. We're also seeing the scapegoating of new immigrants, such as Muslims. For example, Zunaira Ishaq tried to challenge the policy that prohibited wearing a niqab during the citizenship ceremony. This is actually going to be an issue for many Muslims. Zunaira Ishaq herself had no issue with establishing her identity. That happens prior to the ceremony itself. Jason Kenney sought to change that policy. The policy allowed, the existing policy anyway, allowed for the greatest possible freedom to accommodate religious differences. But Kenney wanted that changed, and he did that, and he tried to do that without legislative basis. And that's why Justice Boswell sided with Zunaira Ishaq. It should be remembered that Justice Boswell is a 30-year card-carrying Conservative Party member, and he was appointed by the Harper government himself. And so this is problematic when we see Jason Kenney or the Harper government try to rule by fiat instead of by legislation, and that's why they lost that particular case. It does appear that the Harper government is going to bring in a regulation or rule change that will allow them to deny a niqab wearing woman from participating in the citizenship ceremony. In terms of citizenship, today is Canada Day, and we have seen a fundamental change in the nature of Canadian citizenship under this government. Chris Alexander, the current minister, is defending the so-called Strengthening Canadian Citizenship Act, formerly known as Bill C-24. The fact remains is that that bill creates different classes or tiers of Canadian citizenship. And there's a lot of concern regarding this bill. And it's unfortunate. I think what's happened is that the government is treating the bill or treating Canadian citizenship like a commodity. And the way to increase the value of a commodity is to decrease the supply. And so at the end of the day, Canadian citizenship is harder to get and easier to lose. You've got increased residency requirements. Instead of the previous act, which was 3 years out of 4, you now have 4 years out of 6. I don't really have an issue against an increased residency requirement. What I do have an issue with is that the old act recognized the time that someone spent in Canada towards citizenship before becoming permanent residents. The new act does not. So you could have individuals that are here as international students, as foreign workers, as refugees that have been here for years, but the clock only starts when they obtain the grant of permanent residence, and that's unfortunate. That means that some individuals will be in Canada legally, potentially for a decade before they're granted Canadian citizenship. The changes to Canada's temporary foreign worker program are numerous. One includes the 4-in, 4-out rule. This applies only to low-skilled temporary foreign workers. That means that these individuals that are here, that are working, can work in Canada for a maximum of 4 years. They'll then have to leave for at least 4 years before they can come back. And that has been in place or is in effect since April 1 of this year. Low-skilled temporary foreign workers remain the bonded coolie type of labor, and it's unfortunate that there's no pathway to permanent residence to individuals that have been here for years, that have contributed to Canada's social programs, particularly social programs that they themselves can never access. In all fairness, there was no pathway to permanent residence under the former government either, and it is unfortunate that we do not recognize these individuals and their contributions to Canada. Chris Alexander was the minister when the Express Entry program started in January of this year. The Express Entry program sort of consolidates the Federal Skilled Worker, Canadian Experience class, and the Federal Skilled Trades program and classes. The problem with the CEC is that international graduates and skilled temporary foreign workers have been shortchanged by Express Entry. Under the former Canadian Experience class, there was a clear pathway to permanent residence. Individuals would have to be here, work in a skilled NOC AB0 occupation for 12 months, achieve a 6.0 on their IELTS score or equivalent on a CELPEP, and they would be eligible and would be granted permanent residence. Express Entry has replaced certainty with uncertainty. So now an international graduate or a temporary foreign worker, sometimes in their 20s, is going to be competing against applicants from all over the world. And thus far, based on the invitation to apply and the CRS scores, we don't see a lot of international graduates and temporary foreign workers making the cut. And that is unfortunate. These are individuals that have been here for years. They've spent tens of thousands of dollars on their tuition. They're working here, and obviously they're fluent in English, and and they're known commodities as opposed to an individual that's applying from abroad. It's essential that changes be brought in to recognize international students and skilled temporary foreign workers. Finally, I want to talk about the family class. This government crunched the numbers when it came to filial obligations. Jason Kenney suspended the program in November 2011 without any advance warning. He noted, of course, that parents and grandparents cost the healthcare system hundreds of thousands of dollars, and some went on welfare after the 10-year period of sponsorship elapsed. The program is back up. It opens in January. It's only open for about 2 weeks because there's a cap of about 5,000, and that cap is filled within days. And so what they've brought in is they've doubled the length of the undertaking, 20 years for the sponsorship undertaking by the sponsor, and they want 30% greater LICO or income for at least 3 years preceding the application. So only well-established, affluent individuals are going to be eligible for family reunification in Canada, and that is unfortunate. In effect, these changes have dramatically changed the landscape of Canadian immigration law and policy. Should you have any questions or concerns regarding these changes that may affect you, please don't hesitate to contact any of the lawyers at Stewart Sharma Harshani, one of Western Canada's largest immigration law firms.